in front of the camera and just get that one off our plate.
That's right. Yeah, I don't have, oh, he's out, so they gotta go back. Whenever they out of her, we don't do that. Right. Put your mask on.
In front of the camera and just get that one off our plate.
Right here, I can't stand up though. I got back surgery. Hey, Judge, I can't be able to stand up.
Okay, hi, sir.
How you doing?
Okay, did you see if there's a chair or something available? But so noted, it won't take long. We have your attorney present. Counsel, are we ready? We're on the record calling case number 210444100 and case number 210440099, People State of Michigan versus Dayon Gillum. Counsel, your appearance, please. Go with the formal reading into a not guilty plea on your client's behalf. There's going to be a Zoom pretrial date set for February 2nd, 2021 at 8:30 a.m. to 36 District Court, and it says to both cases, and these will be in front of Judge Garrett, Austin Garrett, and as the bond counsel.
Sure. Mr. Gillum is 49 years old. To my knowledge, he has no prior. He is unemployed. He just got back surgery, Your Honor. Does have GED, has no probation or parole. Understands the no contact order, has no issue with the no contact order. He's living with a friend. I'm respectfully asking the court to consider a personal bond, Your Honor. These are serious, but they are allegations, Your Honor, and we are.
Thank you. And did you see as the bond, do you happen to have any hold information?
We don't have that information, Your Honor.
Okay, that's fine. Thank you, counsel. Court takes into account your representations. Of particular note as to these particular matters that a review of the file shows that the basis of these charges are from alleged matters within approximately 24 hours of one another, also for purposes of establishing the bond and conditions of bond, that it also involves allegations directed toward the same complaining witness, and again within 24 hours of one another. And the court has a concern with regard to what appears to be allegedly a course of conduct by your client directed at the same individual within 24 hours, suggesting an escalation, if not a consistent course of action directed, again, allegations of an assaultive nature directed toward one individual within a very short period of time. The court also takes into account your representations regarding your client's ability to pay. However, those elements, as well as which you indicated was a medical condition, a physical medical condition, that, however, does not outweigh the court's concern regarding nature of the charges and the seriousness of the allegations, as well as ensuring safety to the complaining witness, again, for the reasons stated on the record, in particular that it does include allegations of an assaultive nature in the context of a domestic dynamic. During with regard directed toward the same person. Again, these are allegations only, but the court does take that into account. Further, as it relates to the charges in both cases, this is a second offense notice as to both cases, which means that the cases in front of the court notwithstanding, there is a prior conviction for domestic violence from September of 2019, which lays the basis for a second offense notice as to both cases. So the court, again, is establishing on the record its basis under the criteria utilized on Michigan court rules as to bond. And again, the court is balancing everything, counsel, but the court has indicated its concerns with regard to ensuring safety to the complaining witness at this time. So the court is going to do the following. With regard to case number ending 4100, court is going to set a bond in the amount of $1,000, 10%. More importantly, while this case is pending, your client is going to be subject to Wayne County Sheriff's GPS tether. Also, we're going to mark the file medical. While this case is pending, no contact with the complaining witness.
I haven't talked to my lawyer. I was trying to explain that that lady is not my lawyer who I just got through talking to.
Mr. Gillum, I'm going to advise you now, this is the court speaking. This court is indicating to you now, if it hasn't happened, based on your representations, we're going to go over your rights right now.
Mr. Gillum, my name is Jessica, and you just were interviewed by Attorney Philip Reagan, correct? And we work together here at the misdemeanor felony defender's office.
Okay, and my lawyer, I was trying to say, I had got on the 19th when they arrested me. I have one ticket. I had a domestic violence with assault ticket. That was it.
Mr.
And
Gillum?
then, hold on. I'm talking.
Mr.
Yes, ma'am.
Gillum, Mr. Gillum,
Yes.
I'm only speaking over you to protect you. This is being
Oh,
recorded,
okay.
it's live on
Oh,
YouTube. Anything you say can be used against you, and you might be
okay.
volunteering information that the judge does not have at this moment. So for your own protection, please do not say anything. You will have an
I'm getting.
opportunity to speak to counsel
Okay,
for your
listen.
next
I
court.
am. Excuse me, Judge. Excuse me for bothering your courtroom, and that I have. I thought I had a
Mr.
right to
Gillum?
talk to my attorney.
Mr.
Yes,
Gillum?
ma'am.
Mr. Gillum?
Yes.
Be
Yes.
advised and let the record reflect that your attorney is present. Further, let the record reflect that your attorney has indicated to you directly, not 60 seconds ago, that Madam Attorney, as well as her brother counsel, they work together. You have been interviewed by an attorney, and the attorney who is present in the courtroom with you right now is representing you in the same capacity, sir. So the answer is you have been interviewed by an attorney. You do have legal representation. And further, in the event, again, for good measure, we can go over your rights again, which includes your right to remain silent. Anything that you say at this time, orally or in writing, can and will be used against you in a court of law.
Okay. Yes, I understand that, and I would like to.
So,
I just,
Mr.
I was
Gillum?
trying to-
Mr. Gillum,
Yes. Yes.
you have
Yes,
been
Your Honor.
advised, and the court is making sure that there is a record of that. Now allow your attorney to do her job. Counsel.
And Your Honor, I got the first thought if the court will continue.
Stand by. Court's going to finalize the amendments on this particular case, and then we can move on if you have any additional arguments or anything else that you wish to make as a part of your bond argument. Stand by. And counsel, before we move on to the other case, the court can, if you wish to add on or if you wish to address anything before we address the second case, you're welcome to do that.
No, thank you.
Stand by. All right, counsel. Stand by,
One
counsel.
case, I got two
Without
cases.
on me, I had to turn it off.
I only had one when I came down here. The detectives they talked to me, they gave me two cases. The
But it's
detectives they
still
talked
going on YouTube.
I had one case. That's it. I came down here, no two cases. But since the time limit, now I got another case.
Mr. Gillum? Mr.
Yes.
Gillum, please be advised that this is a recorded session and the court can hear you.
I don't have no money, court. I'm not working. Y'all give me personal bonds. I don't got nothing. I got one case. I want the court to hear me. I'm not wrong. They was letting me out the door today. They was letting me out the gate.
I had
They
to
was gonna let
turn
me go
everything
home.
off.
And then
Start
nobody
up
had talked
again.
to me. They brought up another
To
case.
get this,
That's wrong, man. That's wrong.
it was still going.
Mr. Gillum, I understand your frustration. You will get this taken care of. You will have an opportunity to speak to counsel again before your next court date. Please just let us
Weeks,
get
that's
that.
weeks later though. That's weeks later. You're talking weeks later. You ain't representing me. I was trying to tell you what's going on. If you're my lawyer who I'm speaking with, I'm trying to tell you what's going on. But y'all hung up on me and put me in front of the judge, and you ain't hear me out. And I you talking about weeks later? You know what I'm saying? I got a right. I have a right. That's all I'm supposed to want my right. Because I had one case, only had one case on September 19th. But I waited 72 hours. They said they was gonna release me. So they finally released me, and they ain't bring up nothing. I haven't talked to the detective or anything. And next thing you know, he said I got two cases. All in one case because they made it up because they had no file on me. And they just made up a file. I haven't talked to a detective yet. Not one time. No, I'm supposed to talk to a detective? I haven't talked to a detective not one time. I was heading out the door. They was releasing me.
Mr. Gillum, just give us a moment, please.
You think I'm not upset about that? I ain't talked to the detective or nothing.
What? Yeah, you gotta put your mask on, right? Thank you.
$100. I don't have that. I don't have $100 given. Yeah, I understand what she said. Yeah, $1,000, $100, 2%. What a monitor. I was on my way home. They was letting me out the door. And they said, oh, no, no. And then they bring up a toothpaste. Come on now. We talk to no detective. Please watch the side of the story. Well, I'm supposed to talk to the detective. Don't I have right for that? Yes? Do I? I'm going to ask you, do I? I haven't talked to a detective. I've been here 3 days.
Okay, we're still streaming, we're still recording. All right, counsel, and if we could, please, I'm sorry, we'll pick up where we left off. With regard to case number 210444099, this is the second of the cases that were on the record at this time, and we do have the Zoom meeting up and running again. I'm sorry, if you wish to address anything further, counsel, at this time.
Your Honor, I understand the court's concern, but as the court heard Mr. Gillum as well, and his inability to pay, and he is unemployed due to the back surgery, Your Honor, and it is, you know, we are still in the middle of the pandemic. Is there any way the court would consider a higher personal bond with no 10% is Your Honor?
Counsel, the court does take into account your representations, and again, the court has indicated on the record prior to, we had to take a pause to get the Zoom room back up and running. The court, again, is taking an opportunity to review information in both reports. The court is looking at what is the second of 2 cases that is before the court at this time. The court has a concern with regard, again, with regard to the complaining, ensuring the safety of the complaining witness. Further, as it relates to this particular case, again, the court does note for basis of establishing the bond, which the court does recognize at this time, given the dynamics that the court has indicated. One, to begin with, that this is the second of 2 cases have occurring allegedly within 24 hours of one another, involving the same complaining witness. Further, that your client does have a prior conviction from 2019, which raises this to a second offense notice as to both cases. As it relates to this particular case, this court is concerned about ensuring safety to the complaining witness, that, again, allegedly, upon review of the file, that prior to the officers coming into contact with the complaining witness and your client as well, that as it relates to the second alleged series of events, that your client was upset with the complaining witness for not serving him food. Later on, that escalated, at which time he grabbed a pot, hit her on the right side of her upper back. And further, as to the other case for which the court has already established a bond, that as to the alleged series of events that occurred, as to the other file, case number 4100, that the defendant allegedly grabbed the complainant by her feet and drug her off the couch and out of an apartment and down a hallway, and that officers were able to observe physical injuries, particularly carpet burn marks and bruising on the complainant's right shoulder. And further, the court does note also, and again, the court appreciates that your client does have concerns with regard to the existence of both of these files, but also based on what the court did observe with regard to Mr. Gillum, that the court again has a concern with regard to ensuring safety to the complaining witness. Further, this court, again, given those factors, this court is actually departing far below what it would often do, given the dynamics and the nature of both of these files occurring within allegedly, the basis of these charges occurring within 24 hours of one another. And that is, again, the court reiterates that concern. And for those reasons, at this time, counsel, the court is denying the motion. Again, these are both incredibly below, these are both extraordinarily below what the court would often set with regard to a bond, given the dynamics that are placed on the record. As it relates, therefore, to case number ending 4099, court is setting bond the amount of $1,000, 10%. Also, Wayne County Sheriff's GPS tether. And no contact with the complaining witness, Angelica French. We're also marking the file medical with regard to the no contact order. No contact means no written or verbal communication with this person, no messages to her through third parties. The no contact order also extends to the place of residence and place of employment, and no social media contacts directly or indirectly. The most important thing about this case is the no contact order, because if your client violates the no contact order in any way, shape, or form, he'll be picked up and he'll spend the rest of this case in custody. And again, to reiterate, the court is marking the file medical as to both files. Counsel, at this time, is there anything further?
No, thank you.
Okay, we're all concluded. Thank you, DDC. We're concluded.
Okay.
I did a restart instead of shutting it all the way down and then booting it up again, and it seemed to work.